The short answer is yes. So you have to be a creditor of the relevant company to file for PKPU. And obviously, credit instruments issued by Indonesian companies are structured in different ways. The one fundamental difference that we encounter, and again this is a common difference throughout the world, is that between syndicated loan debt, or debt which is in loan form, and debt which is issued in the form of a bond or a note. Now the key difference here is that in a syndicated loan, a credit, or even a bilateral loan, a creditor will typically be a direct creditor of the relevant company and have direct rights against it. That means that if it's filing for a PKPU, it simply stands up and says, I'm a creditor and the debt due to me is unpaid, and I'd like the company to be placed into PKPU. The situation gets a lot more difficult when you deal with a bond. Now, bonds are issued and exist in many different ways, shapes and forms. But one structure which is very commonly used is where you have a trustee who holds the benefit of the covenants under the bond documents and the benefit of the debt evidenced by the bonds on behalf of a group of underlying investors. Typically, those investors will hold their interests in the bonds themselves through a clearing system, and that means that there's another layer of complexity involved. Now, one fundamental problem is that Indonesia has a civil or legal system. It doesn't recognize the concept of a trust. And so when in the context of a PKPU, you have a trustee standing up and saying that they are the creditor of the relevant company and that they would like to place that company into PKPU, the Indonesian courts and Indonesian management will typically ask, well, what is a trustee? What does it do? Are you the real holder of the debt here, or should I be speaking to somebody else? You say you act on behalf of a class of underlying bondholders. Are they the people I should be speaking to? And so in the context of a bond, there's always a lot of confusion in Indonesia as to whether the trustee or the underlying bondholders should file for PKPU. Now, as discussed, or as mentioned in the answer to the previous question, Indonesia has, or the Indonesian legal system has no concept of the doctrine of precedent, and so previous decisions of the Indonesian courts are not binding moving forward. And that means you have a series of different decisions issued by the Indonesian courts over the years in relation to who should file an application for a PKPU in the context of a cleared bond. In some past PKPUs, the filing has been made by the bondholders. In some past PKPUs, it's been made by the trustee. And in certain circumstances, proofs of claim in the same PKPU in respect of the same bond have been submitted by the trustee and bondholders, and the Indonesian courts have partially accepted both. So there's huge confusion here. And there's one fundamental problem, which is that the issuance of a bond through a trust structure simply doesn't make sense in Indonesia. It's a concept which is alien to the legal system. It's a concept which makes sense in the context of the Western legal systems where the bonds as a financial instrument originated, and it's simply being taken by the credit market and implanted into Indonesia where it doesn't work. And I often say to our clients that Indonesia has its own rupiah bond market, and I often say to them that you wouldn't take a Texan company and ask that company to issue a rupiah bond because it doesn't make any sense. So why take an Indonesian company and ask it to issue a New York law bond through a trustee structure? Again, that doesn't make sense. And so whenever I do get the chance to work on new money deals, I always advise clients, colleagues that using trustee structures in the context of Indonesia is a fairly dangerous game. And that bonds should be issued through alternative structures such as fiscal agency arrangements, and the structure and the document should be adapted so that it's very clear what happens in a downside scenario, and that if there is some kind of insolvency process, either the underlying bondholder or the fiscal agent for the bond, but at least somebody who's clearly determined has the ability to file.